Thanks, Terry. Good evening, everyone. Thanks, Baki Norman, inviting me here again. It's a small world, as I'm sure most of you know, and I do see these guys around more often than you'd think. So it is nice to visit, as well as a lot of you. I see some familiar faces out there. If you don't know me, I'm Turonie. I'm from the Towns Association. We're a statewide association of town governments, somewhat similar to our counterpart, the League of Municipalities, that if you're not a town, you may be familiar with them, or the Counties Association if you're a county. How many county officials do we have here tonight? Anybody? All right. City or village? Bunch? Towns? Anything I didn't mention? All right. So a good mix. I am a town guy, so if I inadvertently use the word town in a sentence, don't mean it doesn't apply to you, okay? I'll try to point out where there's some differences. There are a few differences here and there, and this is why you're going to see the importance of using your municipal attorney. There's a lot of things that are the same, but there's a lot of times when there's a slight difference, you need to go about it in a little bit different way, or we have some different legal authorities at issue. So this is more a general overview, the nature of ordinances and that whole enforcement process, so you can understand essentially what you need an attorney for, if that makes sense, I hope. So, just to get started, this is the agenda today. I'm going to go over each of these topics briefly, but hopefully enough that you understand it if you don't already. First of all, just what is an ordinance exactly? Legal regulatory authorities that you may have in a municipality. Some specific examples I'll mention. What are citations? What are injunctions? What's enforcement mean exactly? Municipal prosecutors, municipal courts, and collection. So there's a number of steps in this process as you're about to see. Stop me with questions anytime, I should mention. And I'll have questions at the end if you have any. First of all, what's an ordinance? What are we talking about here? An ordinance is a law of the jurisdiction. There's some differences. You have a motion, that's usually a one-off. You have a resolution. This is a more permanent type of issue, but it's more to set policy. An ordinance is an actual law of the jurisdiction that people need to follow, or they're in violation. And you can have a punishment for a violation. You need to have an ordinance to have that key. So, just like a state statute is a law of the state, an ordinance is of your local municipality. So who has to follow an ordinance? And this is important. Everyone. Everyone in your jurisdiction. Sometimes we have an ordinance in the books and we don't like it, so we're just not going to do it. We're not going to deal with it. Wrong. Alright? If you don't like it, you have the power to get rid of it, and that's what you should do. Because you don't want to have these violations occurring that can come back to haunt you. Maybe finally someone actually calls the violation and you get prosecuted for it. And there's been instances, and I've seen this in the case law, where courts have overturned an action that a local body has made because they weren't allowed to do it per their own ordinance. Alright, you have statutory requirements, and we talk about mandates and such a lot, but you can put your own requirements on yourself as an ordinance. Things that are not necessary by the statutes, but that is a law in your jurisdiction, and you're beholden to it, just like anyone else. So again, if you don't like the ordinance, change the ordinance. Either rescind it or amend it. Procedure. There's always lots of procedure involved in these things. We're talking about legalese and public bodies and all of that. There's different types of ordinances. You can pass one as a standalone, that's what I call it. It's a piece of paper written out. It's in a file cabinet somewhere. A lot of places have codes of ordinances. Your statutes come in a book. They're not all loose leaf. Alright, you can have basically not a statute book, but an ordinance book in a municipality. That's your code of ordinances method. And if you have a code, you can still pass standalone ordinances or whatnot. That's your decision to have it in that code book or not. What's the difference? Just where they're located exactly, how easy they are to find. So, you have a lot of notice requirements sometimes before and after passage. So how do you know what they are? For before passage, you have to examine the statute at issue. Most of the time you have a statute that authorizes you to have that local ordinance. And it will say right in there if there's a certain procedure required, a public hearing or something else, or how much notice is required if there's special notice. You have to look at it to see if there is or not. Now sometimes the statute doesn't say, or we're not quite following the statute exactly, which I'll explain. In that case, it's just standard open meeting law. Most ordinances, you just need to have on the agenda, that's the notice for your body's meeting, and you can pass it there. That's most things. After passage, when is this law of the jurisdiction effective? It's effective the day after you've noticed it to the public. So when does that happen? Well, in towns we can post. I know in some places you have to publish. But once that notice is out, whether it's posting places or in the newspaper, the next day it's in effect. All right? Unless in that ordinance you specify as a future date. In the last presentation you saw some future dates when things were going to happen. Right? You can specify things like that too. Why would you do that? If you want to give people time for some compliance ahead of time. Issues like that. So, public hearings are possible. That's often one of the questions. Do we have to have a public hearing? You've got to look at the statute. Or, and I've seen this, sometimes you have a local ordinance that says we're going to have a public hearing every time we pass some type of ordinance. Well, you've obligated yourself, so you need to be doing that. So, that's ordinances. Yes, we have a question.
If you have a code of ordinances and you follow the posting procedure and post it, whether it's posting or publish it in the newspaper, but say something happens and you don't get around to actually updating your code until for 6 months.
Yeah.
Was it still enacted the day after it was posted?
Well, you notice it to the public. You duly pass it as a body and you notice it to the public. I would say it's in effect. All right, you just forgot to put it in the book. That's more of a clerical type error. All right, and that's easily remedied because, oh, it's not there, let's go get it. But if you duly pass it as a body, notice to the public, I'd say that's in effect. That's what I'd say. Good question. I knew we brought you. All right. Yes, one more.
I want to follow up on that. We have a company that puts it on our website.
Aha.
Becomes a little bit more, well, it's a timing issue then. And it's very expensive, as you know, to do that, to have it published both in the book and also online.
Online publication means nothing. All right? There's no legal way to putting it on the web. It's a convenience for the public. Exactly. It's one they like. You're going to get more compliance, frankly, if it's easy to find. Right. But for right now, that's a convenience for the public. And it's, if you're allowed to do posting or newspaper publication, it's when one of those things happen. This is Chapter 985 of the statutes. That's why. When one of those things happen, that's the legal notice. A little bit archaic, I know. But when you buy your ink by the barrel, they say you're a powerful lobby, right? So we hope to get that law changed. I'm sure a lot of people do. But for right now, websites are largely a convenience for the public. All right. So the underpinning for an ordinance, you don't just get to pass any law you want on anything you want. There has to be a legal authority that gives you the backing to make that a law. So there are some differences, and here I'll point out some differences. Towns and counties are what's called statutory bodies. You have to have authority that's either explicitly in a statute or necessarily implied therefrom to have the legal authority to do something. That's towns and counties. Towns, in addition, can acquire what's called statutory home rule. This is what's called having village powers in a town. If you've heard these words, public health, safety, and general welfare, that's what's called a police power in the municipal attorney realm, also known as village powers for towns. If you're a city or village, you have not only statutory home rule, but in the state constitution, you have home rule. So you have constitutional home rule. And this can lead to some slight differences amongst these different bodies, and this is what you're going to need an attorney for. There are some things that, frankly, a city or village can do that a town, even with village powers, can't really do. And counties are even more beholden to statutes than that. So these are some of the cause for some of the differences that can occur. So, let me just make the difference between towns without village powers. Towns without village powers, you have to have a direct statute and that's it. Or necessarily applied therefrom. I'll mention we'll get to some specific examples of some statutes and ordinances. And towns without village powers are very limited. We mentioned frac sand earlier tonight. A town without village powers, there is nothing you're going to do about frac sand, just about. Just about nothing. So that's why we've seen some resurgence in interest in village powers and land use regulation. You can only do land use regulation if you have village powers. That's one of the differences. So, what are some regulatory type ordinances? Weight limits. Everyone can do weight limits. You all have highways that you're responsible for, and you can regulate them to protect them from unnecessary damage. That's weight limits. Speed limits. You have some default speed limits, actually, and you have some limited ability somewhat to have a report done and change some of those speed limits. Sometimes people want a lower or higher speed limit on a certain road. That's how you do it. You don't violate a sign. This is important. You violated a statute or an ordinance. So if you just throw up a sign with a different speed limit, you haven't done it properly, you're going to have a little bit of an enforcement problem if it ever comes to that. So it's important to have ordinances that are valid, that underpin your signs. Your signs are the notice to the public of an ordinance. Alright? No parking. Pretty much the same thing. Public nuisance. This would be a village powers issue if you're a town. Public nuisance is declaring something that's just generally to the public in your area going to be troublesome and will enforce against it. Unnecessary noises at certain hours of the night. That's a classic example. Boating. You can all do boating if you have water within your jurisdiction. Boating ordinances require a public hearing. That's one of those. Driveway permits. A lot of people require a permit to have an entrance put on a roadway. Building permits. This can be a state mandate. You have Uniform Dwelling Code in Wisconsin that all of you have to follow. But there's also simple ad hoc ordinances, just an informational permit to help with assessment. Utilities in the road right-of-way. When a utility company wants to put in a line, or even a farmer wants to have piping, they all are supposed to come to your municipality first and ask you. And you might have ordinances with more specific guidelines, but even if you don't, they're supposed to ask you about those. Zoning. So all kinds of different zoning. This would be a village powers issue. If you are a town, you would have to have that. General licensing ordinances. Adam talked about the Cooks Valley case earlier today. That was possible because the town had village powers. It would not have been if they did not. That's the general authority. They don't have a named statute, but that general authority, public health, safety, general welfare, that was their legal authority to make that ordinance. So these are just some specific examples so we know what we're talking about. You can picture something in your head. So, what happens when you violate an ordinance? You're caught speeding. You get a citation, most often. A citation can mean what's called a long-form complaint. If you've ever been involved in litigation with your municipal attorney, and you receive a complaint or they write one on your behalf, it's that long paper where they list all these different points where they feel you were wrong. That's a long-form complaint. You can do that every time someone gets caught speeding if you want. It's a waste of your time. All right? Waste your time. Buy a book, a citation booklet. You can get them from printing companies. That's the ticket book, where you just fill in the lines, check the boxes, refer them to a court date, etc. So a citation booklet is most common. If you're going to get into this business, in that citation book, you must have some identifying marks and have it numbered. Some people, well, I've heard of this before. We bought the citation book, we forgot to put the municipal stamp on it. So you wrote a ticket out, no one knows where to go. Okay? Or that ticket gets returned to the local court, and the court doesn't know what it's about. Alright? So you do need to have identifying marks and make sure those are numbered. So what happens when I get that ticket? It's called a forfeiture. The citation is a piece of paper, but it's called a forfeiture. And it's an amount of money that I either just pay, or I can show up in court and try to challenge it. And we'll get to court. But what's important is, if they don't pay, if it's unpaid, so let's say they don't show up in court, the default judgment, they're not going to pay it, they owe the money, you can never ever put a citation on a tax bill. That parking ticket they owe cannot go on a tax bill. Never for a citation. Why is this? Because it's not a tax. This whole citation area of law is really, it's a subset of the criminal system. And so people have to have their rights. It has nothing to do with property, taxes, or any of that stuff. So never on the tax bill. Yes?
Can a board issue a citation, or do they tell someone in authority to issue a citation?
We'll get to that one. Is that all right?
Yeah.
Who gets to write the tickets?
Yeah.
We'll get to that.
Okay.
Okay? Any more right now? All right. The other thing you can do is get an injunction. Now, you can write a ticket. Let's say you've got the junk cars in the lawn in the neighborhood, right? Pretty common one. And you can have your ordinance written where every day is a violation. So you can write them a ticket every day. And you can encourage stepped enforcement, write a letter first, you're in violation, we're going to start fining you, and maybe they'll just clean it up. Let's say they don't. Now, eventually, what you really want is for that to get cleaned up. Right? You can fine them all day, but what you really want is to get that cleaned up. A court order to do something, or to stop doing something, that's an injunction. That's where the court rules and says, you must stop this, or you need to take care of this. And they'll usually give a time limit. It can be served by the sheriff oftentimes. A lot of times, whether it's in the statute specifically or not, if it's not, you should ask for it when you're at court. After a certain amount of time, can we arrange to have it taken care of? And give them the expense of it. All right, this is an injunction to actually change or stop from changing what's going on that's bothering you. I mentioned law enforcement help recommended for some situations. If they're not removing the cars, and you're arranging for a tow truck, or you yourself are taking a town truck down there to drag them away, you might want to arrange to have a deputy there too. All right? People can get irate in these situations, and that can be helpful to have a presence if you can arrange for it. So how do you enforce these injunctions? They're still not doing it? Well, if they're doing something, how am I saying this? You want them to stop doing something and they're still doing it, right? There's also contempt of court, where the court orders them to come back into court. The court says, are you still doing this? Are you not following my order? That's contempt of court. And the court can fine a person, even have them jailed until they agree to do it. So there is enforcement there. That's injunctions. Citations and injunctions. A lot of times you have the options for both. Zoning code violations, you can fine people. Fines aren't getting it done. Step it up, go to court, get an injunction. So actual enforcement. Here's who gets the right to tickets. First of all, for an ordinance violation, you have a statute of limitations, and it's only 2 years. Not real long. So if you're going to save up the dates that people are in violation and get them later, you can only go back up to 2 years. Keep in mind. Procedure. It's usually pretty easy to tack on procedure. Why? What's the most common thing we do wrong? Forgot to have a public hearing, or didn't notice it quite right, didn't get it noticed to the public soon enough, things like this. You cannot attack the procedure, though, once it's been on the books for up to 3 years. Assuming it was noticed to the public. So once it was noticed to the public and it's been on the books for 3 years, it cannot be attacked on procedure. So, if you have an ordinance that you're not sure about, whether we did it right, what do? Past 3 years, don't worry about it. Under 3 years, you can either sit there and worry about it till you hit 3 years, or just put it on your agenda, do it again, make sure you do it right. From that day forward, you know it's 100%. That's the only real way to cure that, other than waiting for 3 years. So, who writes the tickets? You need to pass yet another ordinance. It's called a Citation Authority Ordinance, and the statute number is listed there, 66.0113. I should mention in your booklet after the slides, there's a partial listing of a lot of statutes that require public hearing, and after that is a sample Citation Authority Ordinance. So, the Citation Authority Ordinance is where you list who can write a ticket for what. This could be a municipal officer, maybe your town chair, village president. It could be someone else, the clerk. Whoever you list in there. You could say designee of the board. That leaves you a lot of flexibility. You might have employees. You might have a zoning code enforcement officer who can write the tickets for that. Or a parking officer. Now, do beware that you're not going to be pulling people over for speeding unless you're law enforcement trained and equipped. All right, there are some differences there you need to be aware of. But parking officials, most people who write parking officials are not fully fledged law enforcement. Because they don't have to be. They're not pulling you over. You're parked illegally. They leave the ticket and move on. Contractors. There's different contractors you can have. I do want to mention, particularly towns, there's the county sheriff's department. The sheriff does have jurisdiction to enforce town ordinances, just so you're aware. They can, you cannot make them. All right, they have things they got to do, and if it's a low priority for your county sheriff to be in your town, you know, handing out barking dog citations, then that's what it is. Now, solutions to that are get your local person who can also write tickets. A lot of municipalities contract with the sheriff to ensure that a deputy is in their municipality so often, and that helps alleviate their cost to do that. So there are options. There's joint police departments, all kinds of stuff. But for the basic stuff, just about anybody you can have able to write those citations. All right. Municipal Prosecutor. If you write that ticket, and the person doesn't oblige by sending their check, and they're actually going to show up for court, this is why there's a court date on it. They have the chance to contest it. Remember, this is sort of like criminal law. In some counties, the district attorney office will prosecute municipal ordinance violations. But again, this is kind of like the county sheriff. They have to be willing to do that. They have other things on the agenda, and you cannot make them be your municipal prosecutor. That would be something you need to check into. The other option is that you have a municipal prosecutor on staff. Particularly larger municipalities have one or more attorneys that are just employees, and this is what they do. They prosecute ordinances at court. Why do you have to have an attorney for this? Can't I just go to small claims? Do that all the time? No. Remember, this is a criminal system. Small claims is that civil system. It's a different system. You do need an attorney to prosecute here. The other issue is to have a private attorney, and you just contract with that person, maybe one of these people from Bobke Norman, and as necessary, they show up and prosecute your case in court. That's probably the most likely scenario for smaller municipalities that are going to do this. So, that citation gets returned to court somewhere. Might be your circuit court, but again, you might have more flexibility and control and activity, certainly, with a municipal court. This is under the chapter of the statutes there. This is up to your own municipality to create one of these. You don't have to have one of these. But if you do, you've got a lot more, everything I mentioned, control, access, everything like that. You can have joint municipal courts, which a lot of these are. Whether they're joint towns or joint city, village, and town, all of that, it's all possible. The judge is an independently elected official from the total jurisdiction. Whole jurisdiction. And they're in charge of the court. They run the court. But the municipalities, or the groups of municipalities, fund the court. You're not going to tell that judge what to do there, but you're going to fund that operation so the judge can operate the court. Now we have different branches of government, right? Executive, judicial, legislative. You all on governing bodies are part of the legislative branch. When you hear the term political subdivision of the state, you're all political subdivisions of the state. That means you're a subset of the legislative branch. If you choose to create a municipal court, it's actually part of the third branch or judicial branch. And that's why you're not in charge inside that courtroom. Okay? So just understand that you can choose to create or not create a municipal court, but you're not running it inside day to day. Really, the judge is the authority there. And that person, like attorneys, answers to the state Supreme Court. That's where that flows down. Any questions on that relationship? Yeah?
Quick question on clerk of courts then. Is that the clerk of courts would be, the judge would be his or her boss, so to speak? Or is it the municipality that would oversee the clerk of courts?
See, this is the issue. You're going to pay that person.
Right.
That clerk who's going to work, even in a municipal court, that judge is going to be in charge of that person.
Okay.
Okay? And it's pretty much the same setup at the state and county circuit court level. Good question. All right.
Okay.
Yeah.
Does the judge have to reside in one of these municipalities?
They will have to because they're an elected official. So this question is, will a judge have to reside in the municipality? Yeah. Is there an elected official? Now, if it's a joint court, they have to live in at least one of them. Good question. Yes?
So if two municipalities were to join the court system, say the city of Richmond, or village or town, there would have to be a new election of that judge to accommodate both land areas?
I'm not sure if it would be right away or the next election, but whenever there is an election after that joint, it would be that entire jurisdiction votes. You know, each person in each place is one vote towards that judge, whoever that is. Yep.
Can you repeat the question?
Oh, I'm sorry. When you get that, when you form a joint court, you know, who's voting on this? The judge. When you have that joint jurisdiction, every single person in that jurisdiction, it'll be on your ballot when you go vote. Make sense? All right. Collection. Congratulations, you've won. Now what? Okay? Or they didn't show up. You get a default judgment. They had a court date, they didn't show up. That's where most default judgments come. Or you won at court. Now you have what's called collection. And it's not necessarily easy. In fact, this may be one of the major reasons you need a municipal attorney for this kind of stuff. How do we get the money now that we're owed? Well, I already told you that the fine itself, when unpaid, doesn't just go on a tax bill. Not that easy. You turn it into a judgment, and then you try to collect the judgment. And once you have a judgment, that's different. A judgment can be a lien on property that's owned. And it can be, you can garnish wages. Judgments gain interest as they're unpaid. And a judgment can last for a long time. I told you about the 2-year statute of limitations to prosecute. A judgment lasts for, I think, 10 years, and I think you can renew it for another 10, is that right? So, long time. And they collect interest as long as they're unpaid. So, why do you need attorney's help with this? Blood from a turnip, right? It can be hard to collect sometimes. It can be hard. So, there's 2 things I do want to mention that I think people are using now to good effect. The first one is what's called a tax refund intercept program. This is part of the Department of Revenue. And what this does is you sign up with them and you register that you want to use their program and let them know of things that are owed to you. Personal property taxes don't work in this, but real estate property taxes work. Citations work in this. What happens is if anyone's owed a state tax refund, they'll intercept that to pay these other outstanding amounts first before they get any amount. So this is a real good thing to sign up for. Once you sign up, I don't believe you have to do too much except wait and hope they get a tax refund. So that's a very good one. Very good program. Another thing I'll mention, and I've heard this more and more, is actually using a collection agency. And just turning it over. You have a contract with this agency. Here's the stuff we're owed. See what you can get. And I've heard people be quite happy with that. They don't get everything. They don't get everything. But what they do get, you know, if your attitude is, well, without them we wouldn't have got it at all, you know, then that's something, right? So some people have been using collection agencies. Something to consider. So I'm pretty much at the end. I did race through this perhaps. So this is where I'll just get on the soapbox here. All of these local ordinances and enforcing them, that local control, which we always like, however, means local responsibility. Alright? Before you complain that we don't want to pay someone to prosecute these things, or we don't have to want to bother with the collection process, or nobody wants to run out there to see if they're parked illegally to write that ticket. If you're not going to do that, then you want to consider maybe not having an ordinance. Because without that effective enforcement, all down the line, they just lose their meaning. And then you get in that situation where, we have these things in the books, but we don't really care. Well, that'll bite you at some point, I guarantee. So, remember that. Local control is local responsibility. I also want to mention something I forgot to mention earlier. Just the nature of an ordinance. Any regulation, what is it? It's a restriction on liberty, right? For your citizens. You shall not do this now. Where is the balance to that? It's that it's necessary and that it's reasonable, right? This is the theory that courts use if someone challenges the validity of your ordinance. Is it constitutional? You know, is that restriction necessary? Does it have a legitimate government interest? So, I like to talk down about code services because of this. I don't need any hands, but I know people use code services. This is a company somewhere that they hire and it sells them 100 different ordinances. Here's your ordinances. You know, we have this huge amount of ordinances now. Well, how many of those do you need? Right? How many of those are you going to enforce? I think it's much better to go pick and choose what you need to make your community better and to use your individual assistants, your local attorney, to get that done. Because you want to make sure it's sound, you want to make sure it's necessary, and that you're willing to go to bat for that ordinance. So I always talk about using the traditional method of seeing what problems you have, what people want, what they need, doing that, and you don't need to do more than that. When you're going to enforce it yourself or collect it yourself, I don't think you need to do more than what you're prepared to do. So I would prefer that you use your local attorney as opposed to code service. That's my pitch there. So why do we do this? Why do we even bother having the ordinance? It's that ounce of prevention versus pound of cure, right? It might be a hassle to get some weight limits. But how big of a hassle is it to have to reconstruct a road earlier? I would say it's a bigger hassle, right? In the meantime, no. But that ounce of prevention, that's worth more than that pound of cure. It really is. Peace in your community. You know, it used to be towns were quite rural, and if you were a mile down the road, you could do a lot of stuff without bothering your neighbor. But we have a lot more subdivisions now, especially you had the fastest growing county in the state for many years here, St. Croix County. Sometimes you need some regulation just so people get along. What's the last one there? Even someone's life. Think about speed limits or boating regulations. If you know there's unsafe boating going on, or at least in certain spots, you know, you can spot these things. A little bit of regulation can promote a lot of safety amongst your citizens. So, that was the pitch about regulatory ordinances, and I'm done with my presentation unless you have questions, so I hope you do. Yes?
Can I go back to injunctions?
Yes, you can.
That type of behavior.
Okay, well, we're talking about unruly meetings, right?
Yes.
All right. Unruly meetings. Well, the real issue at a meeting is that the chief executive officer has the duty to keep order, right? That's a town chair, village president. Not sure if it's council president or mayor. Mayor, county board chair. So that person has the responsibility, the duty to keep order to court. And the steps to that are traditionally, someone's being unruly, you need to stop doing that. If they keep doing it, you can either leave or stop doing it. And if they keep doing it, you know, this is the point where maybe you call a resource, but ultimately you could call law enforcement. I mean, it's disorderly conduct at that point. I know it's an open meeting and you have a right to be there, but open meeting law is the right to watch your government in action. It's not the right to yell at people or jump up and down or be disorderly. It's just not. And so that is an issue where if they can't respect that person's authority, then law enforcement can cite them probably for disorderly conduct. So, what do you do about buildings that are dangerous, that they're even there? It's just in that state of disrepair. I think we've all seen those around. Well, there's what's called a raise order. And either the local municipality, I think the county can issue these too. It's 660413, I believe. There's a procedure in there. It's not a short procedure because we're talking about forcibly tearing down someone's house or building anyway. It gets declared unfit. And yeah, so that following that process, you can get it done. And the cost, if you have to do it yourself, the cost of tearing it down, that can be placed as a lien on the property tax. So that any future potential buyer or whatnot would be able to see that that would be part of the cost of getting that land. That's going to drop the land price. So you can deal with that. There's also a, if it's not dilapidated that poorly, there's a procedure to ask a court again because this goes through a court. We're talking about entering private property. There's a procedure to go on the land and clean it up or take care of a nuisance. Okay, and that's a different procedure. So if the building's still salvageable, maybe you can just do that. If it's not salvageable, that's your raise order. Yep. Yep.
Does it need to be condemned prior to a raise order?
That's part of the process as it gets condemned. Good question. So let's say we've got a border, a municipal boundary, and on one side we're going to have activity that the one municipality is okay with, and on the other side of the boundary that other municipality is not so okay with. What are the options there? Well, I mean, there is a jurisdictional boundary. There is a line in the sand there. So, well, frac sand, we might say, line of frac sand. Anyway. Well, I'm a town guy, so I don't want to promote this too much, but there are, for cities and villages, there are limited authorities for extraterritorial zoning and plat review. So there are some extraterritorial authorities for those types of municipalities. There's things called boundary agreements, where you can just make agreements about this kind of stuff. There are some options there, but ultimately, if you're on the other line, if it's just past the extraterritorial zoning boundary, then it's our jurisdiction. We can do something. So there can be. I just want to say though, we talked about a public nuisance. There's such a thing as a private nuisance. What's the difference here? A public nuisance is when you adopt as a local ordinance, this activity is a nuisance in our jurisdiction. We will enforce it. Could be noise, could be dust, whatever. All right? Now, if that municipality isn't going to have that public nuisance adopted as an ordinance, you might still have a private nuisance claim. And maybe that village might even have a private nuisance claim against that, not the town, but against that activity that's going on. Or individual landowners could probably hire an attorney and file a private nuisance claim. So I won't say there's no legal recourse there. That ultimately there's something. Yes?
I'd like to come back to the condemnation and the raising of the property.
Okay.
Lee, you made it sound really easy.
It's not easy to raise a building.
It's not easy. I think Terry can attest to that. We've been trying to do it in our community for probably 8 to 10 years. And that house is still there, and it is still a public nuisance.
I've only been involved for 1 year.
Okay, Terry's only been involved in 1 year. I don't know what the backstory is there, but yeah, I don't mean to say that that's easy to accomplish. There's a specific procedure. It takes a while because it should be hard for the government to come in and tear down your building. I mean, I think we can agree on that. That sounds like too long. He said it's been 8 years, and I've never heard that actually. But yeah, that's pretty long.